And we're now live, Chris. So here we go on a spectacularly relaxed, collarless Friday. We're both feeling the love on this Friday, aren't we?
Always feeling the love, Frank, always. Welcome, everybody, to our now regular Friday webinar series. My name is Chris Irons. I am a strata advisor, former commissioner for body corporate and community management with Hines Legal, and with me, as always, Frank Higginson, partner, Hines Legal. Welcome, Frank.
Hello again, everyone, and Christopher.
Today, we're covering off on caretakers. I think we said taking care of caretakers, which of course can be interpreted a few different ways, but we are choosing to interpret that positively today. But look, to be fair, look, there are issues on all sides of this kind of debate. We're going to try today, we're not here to solve all of your caretaker issues, be you a caretaker or a committee or an owner. Today, we're just going to try and give the lie of the land about caretakers. What are they? What do they do? What's their role? How does it all work together?
Some fundamentals, I think, to start, isn't it? And inevitably with these things, there's we could probably do a whole maybe 6 months worth of topics on caretakers. So we'll sort of start and chip away at them. But today is a very fundamental one, I think, with some best practice stuff at the end, as always.
I think so, yes. As always, to everybody, please like and share us. It gets us seen more widely, which in turn gets a discussion happening, which I think is in everyone's interests. It also generates some good content for future webinars, as Frank and I were just talking about. You can ask us questions by putting a comment onto Facebook. We will try and get to absolutely as many of them as possible. If we do not get to your question today, you'll see scrolling there on the bottom of the screen. If you do have queries, you can email the address there, which is info@hineslegal.com.au. But look, is it any wonder, Frank, that there is a bit of confusion about caretakers and what they do, because they actually go by so many different names?
They do. And I suppose here's the starting point, isn't it? There's a bunch of confusion between body corporate managers and body corporate caretakers and building managers, and even from a legislative perspective, service contractor, letting agent, resident unit manager, caretaker. And I suppose you see that all the time, strata manager, strata caretaker, can be confusing. The terminology can be confusing in a substantial way. And I think one of the other things I think that has always been for me is Seinfeld. Yes. People walk in and they see the concierge, I suppose the doorman, as much as they're not usually door women in Seinfeld, so will be the door person, maybe would be the non-gender specific word to use, and expect their on-site manager, which is another word, to be there to do grocery collections, let them in, collect papers, all that sort of stuff, which is not what it's about.
Certainly that happens sometimes, but that's definitely not the norm. And I think you've hit on a really good point there, Frank. Right around the world, the idea of there being a caretaker for a building, that's pretty commonplace. I think in the States they're called supers, short for superintendent. Might be janitor, foreperson is another one. But the situation in Queensland, it's pretty unique, isn't it, Frank?
It is, and it's tenure and statutory protection. So I'm smiling at some of the comments here from our frequent followers. So hello, ladies, I suppose. Our caretaking arrangements are legislated. So it's pretty rare in a sense to have an industry that has statutory protection and specific statutory protection. So I suppose you go to things like leases, you go to franchises. I mean, there's national franchise legislation, but in relation to franchise as a whole, as opposed to a specific industry. So the BCCM Act has a headpiece of legislation. Underneath that, there's a range of different modules. And really, from a management rights perspective, we really have accommodation and standard module agreements. Big difference between the two of them is the length of term under which a management rights agreement can be granted. Under the accommodation module, it is 25 years. Under the standard module, it's 10. You do see some commercial module ones, and they can also be 25 years. So it's interesting. I mean, I won't even go there about term and statutory review and legislative change and all that sort of stuff, because that's a separate topic entirely. But The reality is that that's the position that we have in Queensland. Other states are different. Victoria is changing their rules at the moment to possibly bring it back to 3 years. New South Wales has differing caps for their caretakers in terms of 10 years for a caretaking agreement, which is sort of facility management type piece, and unlimited terms for letting agreements. So state by state, the rules are different. In Queensland, which is really where, where Chris and I are located and where our practice is that 25 versus 10-year thing. And then inside that, you've actually got an agreement that can be up to that term. Doesn't mean it has to be for that long, but it can be up to that long. So they are long-term relationships.
It's fair to say that Queensland is unique amongst jurisdictions in how it approaches that particular issue. Let's clarify a few points and let's dispel a few myths while we're at it, Frank, just to sort of get things moving along. So first and foremost, caretakers are contracted by the body corporate. They don't have a direct relationship with individuals, be they tenants or owners, except where that person, that entity, happens to be the letting agent. It's the committee that manage the day-to-day relationship with the caretaker. And I have seen in my former life and in this one, so many instances of breakdown happening because some of the parties do not appreciate that relationship.
And mate, I think it's a really important legal distinction is that a caretaker is not an employee. The caretaker is a contractor. So when it comes to that employment relationship, there's a substantially greater degree of control that an employer has. I can say to our employees, I want you at your desk at 8:30 and I want you to have your lunch break from 1 and be back at your desk at 2 and then be back there at 5.
And he does do that, everyone.
The brutal creature that he is.
Every day, it's no.
Slave driver. In a caretaking relationship, the nature of that relationship is one of contract, and that is where the caretaker must deliver a range of services, and the manner in which they deliver them and the time in which they deliver them is up to them, subject to what the terms of the agreement say. So it's no different to if you engage Heinz Legal to do a job, we quote you a fee to do it. When we do that is up to us, and how I manage that to be done is up to me. I could use any number of different lawyers, but at the end of the day, I'd have to deliver to you a product for a price, which is what I've agreed to do. And a caretaking relationship is that same thing.
Absolutely, absolutely. Well said, Frank. Point 2, caretakers do not enforce bylaws. Caretakers are not the police for that building. It's up to the committee to enforce bylaws, and it is not the job of the caretaker to tow cars, to break up noisy parties, or to approve pets.
Or to skull drag people from the pool when they're in there with glass.
Yeah. It's not the caretaker's job, and that is a big misconception which exists. The only party which can enforce bylaws is the committee as part of the body corporate. There's been some talk about legislative amendments in which a caretaker might be empowered to do that. Hasn't happened yet, probably won't happen, to be brutally honest. For now, it's the body corporate. Frank's already hit upon this next point, but it's a point worth remaking. Caretakers do not perform every single duty at the building. That's not their job. They perform only those things that they are contracted to do and contracted to perform. So I guess the flip side of that is just because you as an owner or a tenant see something that you think needs to be done doesn't automatically mean it's the caretaker's job to do it, does it, Frank?
No. Really, it massively comes back to the terms of the agreement itself. And that's where all of these fights start and finish, really, because if we're going to have a fight in management rights, it's going to relate to the duties in terms of what's required or the standard to which those duties have been performed. That would be 99% of the disputes we have in management rights.
Yep, agreed. Yeah, definitely, Frank. And then finally, a point that often is misunderstood, a caretaker is not obliged to live on site. They're not obliged to operate particular hours, and they're not obliged to have an office open unless their contract says. So a caretaker is not necessarily on tap 24 hours a day unless there is some provision in their contract for that. Isn't that right, Frank?
It is. And then I suppose you go into one of the inevitable things we deal with is what about an emergency? Because one of the things that has been popping up a fair bit in management rights in Queensland is sort of management rights sold without real estate. So they're not necessarily on-site managers in terms of owning a lot. It's a contract. So one of the inevitable issues that pops up from that is, but what happens if there's an emergency? And the answer to that is ring the people that would deal with that emergency. So if the building's on fire, ring the fireys.
Yeah.
If there's an incident of domestic violence, ring the police. If there's a loud party, and we're back to that same situation of pretend you're not in a body corporate, what would you do? That is the same sort of thing that needs to be applied to these things.
And can I say though, Frank, the flip side of that discussion, of course, is that for some caretakers, they will exceed their prescribed duties because it's in their interest to do so. Because there is a financial motivation to do so. I've spoken about this particular scenario in a few seminars when I was commissioner. So I used to be a tenant in a community title scheme here in Brisbane in Fortitude Valley. Anybody that knows Fortitude Valley knows it's noise, 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 party, party, party. Not at my place, I suppose. Anyway, the caretaker of that building in which I lived, he was also my real estate agent, so he let out the property to me. He would actually get my parcels delivered to the foyer and bring them up to my apartment. It wasn't his job to do that. I'm 99.9999% certain he was not contracted to do it, but he did it. Why did he do it? Because he wanted to establish a relationship with me in which I would rent from him in future. And I did. Once I had to move out of the apartment I was in, he found me another one in the building and I rented again through him. So the point being, there's a minimum standard for caretakers and then there's other stuff that they might do purely from their own motivation. Isn't that right, Frank?
It is. And I think the essence is those personal services that he was offering to you builds a relationship with both you and potentially the owner and the committee, because he's probably doing that for other people and looking after them. The essence of it, from a legal perspective though, is that if those duties were, back one step, caretaking salary comes from body corporate levies, which are contributed by everyone. So to me, fundamentally, that means that the services which are provided for the remuneration that's paid to the caretaker should be available to everyone. And that's back to that that concierge style service, where it's not it shouldn't be the caretaker's job to provide personal services to owners as caretaker. As letting agent, they might choose to do that. But that's where that delivery of mail, collection of groceries and all that sort of stuff, that's a plus cost, because if I'm an investor owner and I just keep my property as a lockup, for example, I shouldn't be paying my body corporate levies to have Chris's papers delivered to him every day of the week at the front door. That's just the fundamental nature of what a caretaking remuneration should be and what people pay their levies for.
Absolutely. We might just have a quick pause to address a couple of questions, banking up. Not really a question, but more of a comment, not really on topic, is a statement here from somebody about powers of attorney and how many can be held by committee members. There's no restriction on that at the moment. In Queensland. That may be changing in the not too distant future once the legislation changes. But at the moment, there is no restriction on that. Another question, so a security guard can't enforce bylaws? No. Security guard can do particular security duties, but they can't enforce a bylaw. That's right. Another question, a caretaker has to abide by the bylaws? Yes, they're an occupier. So they are bound by the bylaws. A couple of questions at the end there for you, Frank. Can the duties be reviewed as duties shift over time and remuneration adjusted?
That's a really interesting one. So, and quite often, I mean, agreements, long-term agreements by their nature, aren't necessarily going to be what should be in place for the entire term of that agreement itself. So we quite often have agreements that do tweak, or in a sense of we're prepared based on something that have changed then to become something else. But what I would say, in the absence of a specific provision entitling a review to market or a review of the duties, there's no contractual right. There's certainly no statutory right for a review of caretaking remuneration or duties. So that's normally a matter of commercial agreement. And sometimes you see that we haven't actually taken one the distance. They've all sort of resolved themselves commercially, which is good, where a FOIA might have been something and then it becomes something else. And that something else requires a whole lot more looking after than what it was before. So suddenly the caretaker's got, if we're going to maintain the same standards, an additional It's 5 hours of work a week looking after this new foyer. So what does that mean? So they're the sort of things that have resolved themselves commercially.
Yep.
Oh, minimum standards.
We'll come back to questions. If you do have more questions, everyone, keep asking them. We'll try and get to as many of those towards the end as we can.
WHS there too. Look at all these ones.
Indeed. Let's just keep going a little bit further along those misconception, myth kind of thing. We touched upon this a bit earlier, Frank, but it's not compulsory to have a caretaker.
No.
When you have a really small building, 2, 3, 4 lots, it's quite possible that if somebody lives there and has got the time, inclination, energy, and skills, they could do the caretaking, and there might be some arrangement for that. You have to say, though, Frank, I think that when you're talking about multi-story developments, having a caretaker is absolutely essential at that point. And not only is it essential, it's actually valuable, isn't it?
I think so. And you know, the dispute that always comes up is not so much whether there should be one, it's the tenure for which that a contract is in place. So, and it's interesting, you sort of could compare things state by state, but the reality is that all of these buildings, of whatever nature or size, the bigger ones, have ongoing maintenance needs. So in effect, what a caretaker does is really should take control of all of those things for a committee and allow the committee then to hopefully point and shoot, as opposed to have to be involved in doing the work or managing the work being done, because it's not the body corporate manager's role either. The strata manager, hopefully at this stage, is sitting back at their office paying invoices as required and not actually out yet. They're not coming on site to make sure things are done. So it's the coordination. You know, you add pools, you add lifts, you add a whole bunch of things. Who's actually making sure all that stuff works?
Absolutely. Someone's got to do it, don't they?
Absolutely.
And look, I think what Frank and I have been talking about, I think everyone who's watching and listening today or watching and listening afterwards would be getting a sense for when it comes to the general topic of caretakers, in my former role as commissioner and this role, and certainly Frank and his vast experience in the sector, have heard a lot of concerns about and complaints involving caretakers. Where does that actually all come from? So in my view, Frank, you might take a different view, but in my view, it starts with a lack of understanding of the roles and responsibilities on both sides.
Mate, it starts with reading the caretaking agreement.
Yep.
That is the core document, and that is where it all starts. The amount of disputes we've had that have appeared on our desk where no one on either side has read the agreement are extraordinary. And
again, it's worth reminding people that the technical term for a caretaker is a caretaking service contractor. The key word being contract. If you're going to go ahead and enter into a contract without getting it vetted, checked first, well, you suffer the consequences, don't you? I'm sorry to be that blunt, but there it is. Another reason why there are problems is the unrealistic expectations from both parties. And I talked about that a little bit earlier, where there's this idea that the caretaker is on tap 24 hours a day to attend to every single issue that occurs. And we've already clarified that that's not the case. The flip side is the case as well, with the caretaker having an unrealistic expectation of what the committee should and can do. I've got to say, and again, please feel free to argue with me on this point, Frank, and everybody else, but in my experience, it's only a very small percentage of instances where there is a caretaker who is just flat out unwilling to do the work.
Agree. Yeah, agree. And the problem, you know, and this, I suppose, is again one of the reasons Chris joined us is, you know, when people come to see us as lawyers, the reality is that there has probably already been some substantial argy-bargy and sort of stones thrown, nasty letters written. Okay, we want to sort this out, and that's either for the body corporate or the manager, because we act for anyone who comes in and happens to pay us where we don't have a conflict. That's the commercial creatures that we are. And at that stage, the horse is bolted to a degree because everyone's entrenched. Where we're trying to get to with these things, with Chris as well, is that if this education process, what we're talking about today, is handled a lot better, a lot earlier, a lot of the reasons to see lawyers actually goes away, because those expectations are set, roles are understood, and managed.
Yep.
You know?
Definitely. Definitely. The ideal, Frank talked about this earlier, and I can only reiterate it. The ideal model is where you've got committee, caretaker, and body corporate manager all interacting as a cohesive whole. So you've got that role over there, you've got that role over there, you've got that role over there. The combination of all of those parties interacting is that everything at the building gets done in the way in which it needs to be done. Things are addressed. There is a clear path for addressing things. Life goes on. I'd stress, it's not important, I don't think, that everyone is best friends. So you're not aiming for a situation in which the committee and the caretaker are having dinner parties every weekend and are best mates. I don't think that's realistic, or indeed probably preferred or preferable in some cases. What you need is everybody with a benchmark of mutual respect, an idea of what everybody is meant to be doing, and then you go ahead and you execute. What do you reckon, Frank?
Completely agree. And mate, that is no different to what we're trying to do with our office. So I suppose for those of you that don't know me, I can be a bit random in terms of my ability to operate in a chaotic environment. Chris has come from an environment that is very structured. So he's bringing some discipline to my life that I have never had before, which I really need. And that's expectations, and that's setting out what ground rules are, and that's letting everyone know what they should be doing. And if that happened in strata, it would be a lot easier. And it certainly should happen in every working environment, which is what a body corporate is.
Absolutely it is. Let's try a few questions, Frank, because there's a few there.
Yeah, no.
Can the duties be reviewed? Oh, we know we did that one.
That.
What is the minimum standard? That's a fantastic question.
It is.
There isn't a legislated standard. It really is what's in the contract. There are a few parties, I guess, who are out there trying to establish an accepted industry-wide standard, which is admirable, I think. I don't know, though, that a one-size-fits-all option is going to work. Frank?
I agree. And, and this is, I suppose where we get to with drafting any document is you want to be as clear as possible, but there's always going to be an element of subjectivity to it. So, the problems in management rights agreements are mow the lawn as required. As required by who? To what standard? And that's where these standards are coming from. A couple of people saying, well, if you're mowing the lawn properly in winter, it should be to 1.5 inches.
Says who?
Yeah, exactly. And for me, the corresponding side of things of that is if you've got a particular standard, because the duties are one thing, the remuneration is another. So if you want things to this 5-star, first class, Versace, want a better brand standard, then that comes at a probably more substantial cost than
you pay Versace rates, don't you?
Absolutely, yeah. You're not buying Corollas, are you? So
no.
They're two sides of the same coin. So I think a standard conversation without talking about remuneration is academic.
How does BCCM fit in with workplace health and safety, Frank?
Well, from a spectacularly named Frank, there's not too many of us around, so thank you, Frank. There's a newsletter on our website. What does a committee and the board of directors of BHP have in common? So if you Google that, and that's all about work health and safety, that's a separate webinar on its own. But if you want a macro view, bodies corporate that have some form of business operating from them are caught by the Work Health and Safety Act, and that business can be a letting operation from a management rights perspective. And if that's the case, then the body corporate has a workplace that it must keep safe, not the caretaker, but the body corporate.
Yep. Can the caretaker claim reimbursements for work done, or does any money spent from body corporate funds need to be voted on and approved by committee, even for small amounts?
Latter question. Absolutely. So when you've got a caretaking agreement, it says you must do duties of X, Y, and Z. If the caretaker does work that's outside those duties, then in theory, yes, they are entitled to charge for it. But from my perspective, best practice is absolutely engaging with the committee up front and saying, hey, I'm required to do this, or you've asked me to do this. That's not inside my scope of my duty. Here's my quote to do it. Yep. And that's the same parallel. I quote you $3,000 to do a job and I bill you 3.5. You're entitled to say, Frank, what the hell's that about? And I come back and say, oh, well, hang on. I did some more things that were outside scope that I didn't tell you about. And it's like, well, that's not really the way to do it. So that's the same way caretakers should operate in my book. Not surprise invoicing, management of expectations up front.
Well said, Frank. If a caretaker's contract states they must reside in the complex and they don't, what does that mean? Well, it means they're in breach of the contract, I'd suggest.
Black and white. Absolutely. There's not much subjectivity about that one. And again, you've got to make sure the wording is very specific because it can, So every contract.
Probably the only thing I'd say there is it might be a good idea to ask why they're not living on site. There might actually be something that is quite reasonable. But even so, it's still something that needs to be addressed. Next one's more of a comment than a question. Owner caretaking is an issue with insurance. The manager said I would need to get public liability insurance to even sweep the courtyard. From that, I'm interpreting that you as an owner are out doing some work on common property. The caretaker's probably quite right in that instance. Frank?
Yeah, I think so. From a body corporate perspective, endorsing owners working on common property, which is really what you're doing, without insurance is a dangerous thing.
Yeah, very much so.
And I'm not the typical lawyer that tries to scare the daylights out of people with threats, but if people are out there mucking around in gardens and the body corporate saying, yeah, go for it, and someone does their back, what happens?
Yep. I agree. Confession time, I used to own a lot in a community title scheme, and it was the sort of building where all of the owners lived on site and would have working bees. And I remember one particularly busy weekend where the gardens were tidied up, the pool was cleaned. As far as I'm aware, there was no insurance for that. Frank is absolutely right. You've got to take a lot of care with that sort of thing. We haven't even begun to scratch the surface on this one today, have we, Frank? And we are almost out of time. So I think we're going to have to defer quite a bit of content to a follow-up event. But just maybe a couple of closing statements from Frank and I. I think what I would say, you've got to remember couple of really important points. If the relationship with the caretaker is dysfunctional for whatever reason, and you can blame either side for that to a certain degree, then it's highly likely that your life at that building is going to feel dysfunctional as a result. The other thing to remember is that maintenance improvement is unlikely to get carried out under those circumstances. So you've got to remember there is a lot of motivation to get the relationship involving your caretaker up to an acceptable standard. And the point too, from the flip side of that, caretakers can often pay an extraordinary amount of money for that right, for that contract. It's in their interest to maintain the building and to do the job. So there are motivations on both sides of this debate, aren't there, Frank?
There are. I mean, and the reality is that no one, unless you're a complete psychopath, enjoys dispute. That's the reality of it. It's stressful. I mean, another seminar we could do is why not litigate? I've been through that as plaintiff, defendant, and lawyer, and it is stressful. So, and you add that pressure, and as much as people don't necessarily show, because some people are good at poker faces and those sort of things, it does build stress. But from a management rights perspective, managers that have invested a lot of money potentially have their life savings tied up in something. They've got a big bank loan from a bank, and they have a massive commercial interest to make sure that their investment is protected. Where we get to from a committee side of things is the committee might be exceedingly unhappy, but they're volunteers, so they don't have that same commercial incentive. It's more a matter of principle. But it's in everyone's interest to sort the issues out. Now, I suppose that's another webinar, Chris, talking about how to resolve issues without litigation. And there's a range of commercial means to do it, one of which is mediation, which Chris is offering, and we've got a couple of those on the go at the moment, and they are management rights matters. And there's sort of some commercial outcomes out the back end of those things that can allow people to move on and save some of that face.
Yeah, absolutely. I couldn't agree more. And if that relationship is not in a good place, then forget about the money, forget about the legal side of things, forget about things not getting done at the building. The impact on one's sanity and emotional well-being is profound. And unfortunately, being in the industry that Frank and I are in, we have seen and heard the very worst instances of it not working out. Yeah, you don't want that to happen.
And sometimes you've got to be the bigger person.
Yep.
in terms of, yeah, okay, they're there, and that's being the caretaker or being the committee, aren't doing the right thing. What's the best way to get this back on track? And the best way to get it back on track is lawyers should be our last resort. And that's where the Chris's guidance of the world in terms of how to get to where you need to go without the need for letters of demand and those sort of things. Absolutely. Because I've said to clients all the time is that you never are going to lose the right to go legal. So if you want to go DEFCON 1, absolutely, I'll fire the biggest rocket you want across to them, and away we go, and it costs you lots of money, and there'll be blood all over the floor, and none of it will be mine, and the lawyers are the only winners. But if you can avoid that, there's a range of ways to do it, and whichever side you're on, it is very much worth exploring those before you actually lawyer up in a formal sense. So talk to us about helping sort the issues out without the need for our active, overt involvement as opposed to guidance behind the scenes.
Yeah.
We're seeing a fair bit of that at the moment as well as we start to get the word out about there is an alternative.
Absolutely, there's an alternative. We are going to have to wrap it up at that point.
Half an hour of my life I just never knew just was missing. It's incredible how these go.
Look, it's pretty obvious that we'll need to do a part 2, probably a part 3 and a part 4 for that matter on this topic. So what I would say to everyone, first of all, thanks so much as always for tuning in. If you do have queries or issues involving caretakers, be you a caretaker or be you committee or an owner, by all means, chuck some comments onto our Facebook page. That is where we can pick it up for next time. Frank and I have got plenty of content to go on with, but it's always good if it comes from the people watching. We want to be responsive.
We've got a bunch of frequent watchers now, which we both appreciate. It's great.
We do appreciate it. Yeah, it's nice. It's nice to have a little fan club. Stay tuned for our webinar topic next week, which gets released on the page. That's where you can get the updates. Again, if you have queries after the event, I think that's now been posted on our Facebook page. In fact, queries after the event, info@hindslegal.com.au. And again, don't forget to like and share if you can. Frank, it's been an absolute pleasure.
Always, mate. Thank you, everyone, for joining us.
Thanks so much again, everyone. We'll see you next Friday.
Bye.
Bye-bye.